the title of this presentation is Civil Procedure, its Salient Features. I have these subtitles to cover under it. I will make it as introduction reads parties, evidence system, fair hearing doctrine. So I proceed. There are learning objectives. I do hope that at the end of this presentation, especially students will be able to understand what is meant by civil procedure, know and appreciate its basic features, and finally know the importance of fair hearing. So what is civil procedure? So that is the most important thing. To put it simply, civil procedure can be defined as the process that determines how a civil case starts in court, how it is conducted, and how it is finally determined by a court. So civil procedure, in other words, is the body of rules and laws that govern how a civil case is commenced, how processes are filed, how they are served on parties that ought to be served, then when the hearing itself will commence, how the hearing will be conducted in terms of stages, in terms of whether there will be a stage when the case will be for mention. That is, the court will just try to know the state of things, whether all the papers that need to be filed have been filed. When it will move from mention to the stage of hearing itself, or whether there will be applications, whether applications on notice or ex parte applications. When we say ex parte applications, those are applications that can be made without putting the other notice and the other party on notice. So it's just one side that is making the application and the court will be hearing. And interim injunction is an example of an application that can be made ex parte. So that is an application that has to be made because of emergency or some exigencies. It has to be made without putting the other party on notice. That is ex parte application. So that is also covered in the civil procedure. The orders that court can make is also covered by the civil procedure. Then the evidence, how evidence will be taken. So these are the things that is covered by are covered by civil procedure. Then the civil procedure can be compared to criminal procedure. Criminal procedure also has its own parts. Then another question is, what is meant by civil case? Civil case, when we say civil case, what do we mean by civil case? Yes, by civil case is when we talk about a case that does not have anything to do with crime. When somebody has not committed a crime, we say, okay, that is a civil case. Like breach of contract is a civil case. Like negligence, let's say somebody who owes another person a duty of care, a doctor to patient, for instance. So a doctor to patient, there is duty of care that you treat that person with care. So if a doctor is performing surgical operation and forgets some implements used inside the part of the body where the operation is carried out, so that's negligence, because that can actually affect the health of the patient in some serious way. So the patient can sue the doctor. So the doctor has not really committed a crime, because it's not likely that it was done deliberately. It was due to negligence, not being careful enough. So in that regard, then a case of negligence, which is a civil case. So meaning that even if the doctor is found to be negligent, there won't be any criminal consequence in terms of sending that doctor to jail or imposing any fine on the doctor. So it will just be damages. As damages will be paid to the claimant to the patient who has initiated a civil case. So civil case can also arise from landlord-tenant relationship. Let's look at a situation where a tenant who has a duty to pay rent fails to pay rent. So the landlord can also sue the tenants in order to recover the rents. So that's also a civil matter. So all these cases like that, they will come under civil procedure. So they will be governed, their determination in court will be governed by civil procedure. So that is what we meant when we say civil procedure and civil cases. Then there are ends, there are prayers, we call it reliefs. There are reliefs that a claimant or plaintiff, as the case may be, who has approached a court in respect of a civil matter can obtain from court, where we have reliefs like damages, as I've mentioned before. Then we have specific performance. We have injunctions. It can be perpetual injunction. We have rescissions. These are some of the reliefs, some of the claims that can be made in respect of a civil matter in court once a civil suit is filed. So we move to another slide. I have given examples of civil cases. I've mentioned breach of contract before. Defamation is another example. Defamation is another example of civil case. Defamation is when you say things that are not true about another person, which bring down the reputation of that person. For instance, if you say somebody is a thief, when it is not true, when that person has not stolen anything, or when you cannot prove it, so you bring down the reputation of that person, you damage the reputation of that person, so that person can sue you and claim damages for the reputation that has been brought down. Then land disputes. Okay, when two people are claiming ownership of the same piece of land, so either of them can file a suit for the court to determine who is the real owner, who can actually substantiate his or her claim in a court of law. So if there is a dispute over ownership of land, it's not a criminal matter, it's also a civil matter, and it will be governed by civil procedure. So I've mentioned negligence before. Then indebtedness, somebody is owing you some money, maybe in respect of contracts, or you have done some job for somebody and that person is not paying you. It's also a civil matter, so which cannot lead to criminal issue. Then, for instance, if a student, if studentship of somebody is terminated, okay, and that person believes that the termination of studentship is wrongful, it's also a civil matter which that student can challenge in a court of law. So we have rules and laws, that examples of rules and laws that govern civil procedure can be found in rules of courts. Different courts have their rules. High courts, all high courts have their civil procedure rules. Magistrate courts also have their rules. Then even in the laws that set up a court, for instance, let's say High Court of Osun State Law, or High Court Law of Osun State. So that's a law. So there are rules that govern civil procedure that may be found, maybe in terms of how suits, the modes of commencing civil cases in court. So can be found in the High Court law of that state. The Constitution also has rules that are applicable to civil procedure. We have human rights. Some of the human rights, they are applicable, especially the one dealing with fair hearing, which I will talk about it in details later. So the Evidence Act also has something to do. The matrimonial causes rules, especially if it has to do with if that civil suit is a divorce matter. So matrimonial causes rules will apply. I move to another slide. Now, writ. What do we mean by writ? So writ is simply a document, it's a mode of starting a civil case, especially in the High Court. In the High Court, that is where writ is used. It is technically called writ of summons. writ of summons, and is used where facts are going to be in dispute. For instance, if two vehicles are involved in an accident and none of the two drivers is ready to admit responsibility, so they are coming up with different narratives. This one is saying, oh, he drove this way and that's why the accident happened. No, he was the one at fault. No, I was not the one at fault. So they are giving different accounts of what has happened. So if that case gets to court, then it will be better dealt with through writ of summons, because other modes of commencing a civil case will not be applicable in that regard. And there are so many other instances where writ of summons can be used, but generally where parties have serious disagreements, they don't have agreement on the circumstances leading to their dispute, so it is better they go by writ of summons and not any other mode of commencing, because if they go by any other mode of commencing and their suit in court, then there will be technical issues. The case will not be able to proceed because of the wrong procedure that has been applied. So it is important that writ of summons is used where facts are seriously in issue. Contract matters, contract issues too, writ of summons can be used. A student whose studentship has been terminated, writ of summons can be used. So there are so many instances where writ of summons is the most appropriate mode of commencing action that should be applied. So I move to the next. So I still continue on the writ of summons. Now, there are other means of commencing civil cases in High Court. For instance, we have originating summons. We have originating. This should be originating motion, not original motion. That's is a typographical mistake. It should be originating motion. Then we have petition here. So then, all these processes, all these modes of commencing cases in High Courts, they are referred to as originating processes. All of them are referred to as originating process because they are the first set of processes that may be filed in court depending on the nature of suit that has been taken to court. Originating summons is used where maybe disputes, facts are not really in dispute. Maybe there is a document to be interpreted, for instance, a will, where there is misunderstanding as to what a particular clause or portion of a will is saying, is open to different interpretations. Then court can be approached through originating summons to interpret, because the primary duty of court, the judiciary, is to interpret laws, interpret documents, is that of interpretation. So the court will give it meaning. This is the meaning, though by the court will first and foremost listen to especially lawyers of those parties before the court will arrive at what the written words in that document is talking about. It can also be a law that is being litigated on and it has to be interpreted. So originating summons to be applied. Originating motion is usually used for enforcement of fundamental human rights. So if somebody's rights has been violated, we have rights under the Constitution, especially Chapter 4. We have many rights. We have right to freedom of movement. We have rights to freedom of association and assembly. So if any right is alleged to have been violated, or is being violated, or about to be violated, so a court of law can be approached through originating motion. Then petition. Petition is usually used in election cases. Election cases when parties have contested and there is dispute. Or it can also be used in divorce matters. So petition is the appropriate. So if somebody wants to file a divorce suit and goes by writ of summons, of course, the court will not be able to entertain that. That case will be struck out. Then the same thing will apply if it is commenced by originating summons or originating motion. That case will be struck out because These are not, and none of them is an applicable means of commencing such suit. That is a divorce matter, which is a matrimonial dispute. So it is commenced, it is usually commenced by petition. So then after the filing of writ of summons, where writ of summons is used, then the parties will have to file statement of claim, especially the parties that approaches the court first, that has taken the case to court and making some claims before the court, we file statement of claim. The parties who approaches court first is known as claimants. I will also come into that later. Then the party who has been sued, that is the defendant, will file statement of defense, that is to defend himself or herself in respect of the case that has been filed in court. So these are the documents that will contain the facts of each party, that will contain their case before the court. So statement of claim, statement of defense is very important. I move to the next slide. Parties. So who are the parties in a civil suit? Parties in a civil suit, especially in high court, are defendants. Claimant first, then defendant. Claimant is the initiator of the suit, while defendant is the person who has been sued. So these are the parties before a court of law. So, and usually the claimant is a party who feels wronged by the action of the defendants, so, and is seeking some reliefs before a court of law. The reliefs can be in form of damages, it can be in form of declaration, it can be in form of injunction, it can be in form of specific performance. So, as I've explained, defendant is the party who is being sued, and claimant, against whom claimant is making some claims in a court of law. So, I still continue with parties, that if the case is before a magistrate court, then the parties will be known as plaintiffs and defendants, not claimant again, but plaintiffs in the case of a case filed in magistrate courts. So, in fact, as a matter of fact, before we have the new rules now, the new rules that brings a lot of changes to civil procedure in high courts in Nigeria, we used to call claimants plaintiffs even in high courts before, but now in most courts, in most states that have embraced the new procedural rules, which is all about front loading of documents, they refer to the initiator of a civil suit as claimant, not plaintiff again. Then evidence system. Now, cases in court, it is based on evidence before the court that a court of law will determine the case or cases that parties have brought. So an evidence can be by oral testimony in court, and can also be by documents, and can be by the both. Oral testimony can be given, then documents can also be tendered from each of the parties. So the court will hear this side and hear the other side. So, and parties can also engage their lawyers who will present cases for them. But when it comes to giving evidence on the fact in respect of their case, it is the duty of the parties, of the claimants and the defendants, to speak in court, while their lawyers will be leading them, giving them appropriate questions, so as to get the main issues between them resolved by the court. So parties can give evidence by themselves, and they can also call other people to give evidence. Take for instance where accident has happened, and somebody is a witness, or somebody played a role in that matter, you can also call that person to come and give evidence that will be favorable to your case, so that the claims that you have brought before the court would succeed. So you can do that. So, but basically, a claimant bears the burden of proof in a civil case. So a claimant has to prove his case or her case, and unless a claimant succeeds in proving the cases before the facts before the court, then that claimant may not succeed, unless may not have the judgment of the court in his or her favor. And that is why it is usually said by lawyers that he who asserts must prove. So it is the duty of the claimant to prove his case, and the claimant may not even be able to rely on the weakness of the defendant case. So it is quite important that a claimant adduces sufficient evidence to prove case in court. So stages of evidence in court: we have examination in chief, we have cross-examination, and we have re-examination. So examination in chief, that is the evidence that the claimant will give before the court, which is usually favorable to his own case. Once the claimant is through with his evidence on the examination in chief, then the lawyer to the defendant will stand up to throw questions to the claimant in the witness box, in order to also make the claimant give evidence that may either show that the claimant has not been a witness of truth, has not been saying the truth while given evidence in under examination in chief, or to also adduce evidence, pieces of evidence from the claimants that will be favorable to the fact that the defendant has put in his statement of defense, so that eventually the case of the claimant may fail. So re-examination is used, is the lawyer to the claimant that will stand up after the defendant counsel lawyer is through with the cross-examination, to ask questions in case if there are areas that need to be clarified. So re-examination is only necessary where there is any ambiguity that needs to be clarified. In most cases, there may not be need for re-examination. So standard of proof in a civil case. Standard of proof in a civil case is on the balance of probabilities. So it's just like the court looking at which of the evidence of the two sides is more believable. Is more believable, and if the court believes the evidence of the claimant more than the evidence of the defendant, based on the quality of evidence that has been given in court, either by the claimant and his witnesses, if there is any, and even the evidence of the defendant, where the defendant is also conceding to some of the things that the claimant has said, then that may help the court to arrive at a conclusion that the evidence of the claimant is more believable in the circumstance, and therefore the claimant will be entitled to the judgment of the court. But if the court feels otherwise, that the evidence of the claimant is not convincing, then the case of the claimant may fail, and therefore the case will be dismissed for being unable to prove to justify the claims before the court. So it's just like it's as if an imaginary weighing of evidence, which one is heavier than the other. So that is what balance on the balance, and that is proof on the balance of probabilities is all about. It is not like proof, the standard of proof that is required in a criminal case, which is proof beyond reasonable doubt. That is, if there is any case against somebody in a criminal, against a defendant, because a party who is being prosecuted in a criminal case is also known as defendant. It used to be accused person, but with the coming into effect of Administration of Criminal Justice Law or Act, that accused person, the word accused person has been removed. So we call those people standing criminal trials for criminal cases are also known as defendants, but any case against them must be proved beyond reasonable doubt. Then the last part of this presentation is fair hearing doctrine. So what do you mean by fair hearing? Fair hearing is a constitutional provision, is found in section 36 of the 1999 Constitution. It has been in Nigerian Constitution as far back as either 1960 or 1963. Yes, it has been in the Constitution, and it is all about giving parties in any case, either civil or criminal, fair hearing. That is the two most important pillars of fair hearing are that the judge who is determining the case must not have personal interest in that case. So must not have any personal interest in the case. The interest of the judge must just simply to say that justice is done, that the case is adjudicated according to the fact before the court and the law, and not according to the sentiments or personal opinion of the judge himself, and not that the judge personally is affected by that case or a relation of the judge. If it is shown that a relation of the judge has interest in the case, most times the judge will have to excuse himself or herself. And if the judge does not do that, then one of the parties affected by such interest may bring an application before the court for the court to excuse itself. And if a court fails to do that and sufficient evidence is shown on appeal, then that judgment may be set aside for violating the right to fair hearing, which is a fundamental human right in the Constitution. So the other part of fair hearing is that every person who has a case in court must be heard, must be given the opportunity to be heard, unless if somebody deliberately refuses to be heard. Take for instance, if somebody is served all the necessary documents for the person to be in court, a claimant files an action against another person, and the defendant decides not to come to court. So if a defendant decides not to come to court, the defendant has the right not to come to court. What the claimant needs to establish is to satisfy the court that defendant is aware by producing proof of service of documents on the defendant, of court documents on the defendant relating to that particular, touching on the matter itself. So once the court is convinced that defendant is served, and defendant has been given opportunity, not just once, not been served once, but each time that the case is coming up and the defendant decides not to come to court, then in that regard, a judgment can be given against the defendant, and defendant will not succeed on appeal by challenging the judgments on lack of fair hearing, because it is the defendant who waived the right to fair hearing. So, but if that is not the case, then fair hearing must be complied with. The rule of fair hearing, right to fair hearing, must be complied with in every case. Civil case, it must be complied with. And as I said, a judge must remain, when we say a judge must be unbiased must not have any interest, must not be partial, and must not take side. So nemo judes in causa sua. So you don't take side, you don't get personally involved in the case too. Nemo judes in causa sua means nobody can be a judge in his own case or in his own cause. So if the judge has personal interest in that case, so it cannot be, because if that is the case, then the judge is going to give a judgment that favors that judge. So, and that will be contrary to rule of fair hearing. That means somebody has been helped to take undue advantage of the other. So the other side is that somebody must be heard before being judged. That is altera or audi alteram partem. So that is the rule. I move to the next slide. Now, under this fair hearing principle, it is also part of the rule of the right to fair hearing that a civil case must be heard within a reasonable time. Within a reasonable time, it has been decided in some cases that when a civil case is still in court for upward of 3 years, reasonable hearing of that case has been violated, and that case can be nullified. Any judgment can be nullified. But things that can bring about a case not being heard within a reasonable time can be due to incessant applications for adjournments, and that is why a court has a duty to ensure that parties guilty of making unnecessary applications for adjournments, they are penalized, maybe by imposition of some money, by payment of some money on them, so that they will know that the court insisting that the case must go on if there is no any reasonable ground for adjournment. Then the judge must be independent. The judge has to be an impartial, even if or magistrate, even if a private citizen is suing the government, the judge, despite the fact that the judge was employed by the government, the judge must still exercise independence. That independence of the judiciary and impartiality has to be there. It's part of rule of fair hearing. And the case must be heard in public, that is, in a courtroom where members of the public would have access to the proceeding of the court. It's important, not in one hidden place, not in the chambers of the judge. It has to be in the open court, so that apart from the parties involved in the case, every other person watching the proceeding can also say that justice has been done. So because justice must not only be done, it must also be seen. So that's the end of my presentation. I invite you again to like this video and to subscribe to Kenny School of Law. Thanks for watching.